So my question with respect to the major questions doctrine is this, we accept that it's not our role to decide public health questions, but it is our important job to decide who should decide those questions. I think we all agree on that. And here our choice on the one hand is a federal agency, and on the other hand, the Congress of the United States and state governments. Now, you argue we should not consider the major questions doctrine unless and until we find a statutory ambiguity. I understand that. But let's say the court does find such an ambiguity. I know you'll contest the premise, but let's just work on it. If there is an ambiguity, why isn't this a major question that therefore belongs to the people's representatives in the states and in the halls of Congress, given that the statute at issue here is, as the Chief Justice pointed out, 50 years old, doesn't address this question. The rule affects, I believe, we're told 80 million people, and the government reserves the right to extend it to every private business in the country. Traditionally, states have had the responsibility for overseeing vaccination mandates. I rejected a challenge to one just the other day from New Mexico. Congress has had a year to act on the question of vaccine mandates already. As the Chief Justice points out, it appears that the federal government is going agency by agency as a workaround to its inability to get Congress to act. The risks imposed here are not unilateral. There are risks to those who choose not to be vaccinated that they're trying to avoid sometimes, as you discussed with Justice Alito and conceded to him. Traditionally, OSHA has had rules that affect workplace hazards that are unique to the workplace and don't involve hazards that affect individuals 24 hours a day. So that's kind of the general tick list we have before us. And I'd just like you to address, again, the question, assuming the statute's ambiguous, why isn't this a major question that normally under our Constitution would be reserved for the people's representatives in the states in the first instance and in the halls of Congress in the second?
So accepting the assumption that there's an ambiguity, which of course we disagree with, as you know, I think that many of the factors you identified are just simply inconsistent with the whole premise of the OSHA Act. So it's true that states have a police power over health and safety, but as this court recognized in the Gade case, Congress in enacting the OSHA Act specifically brought the federal government into the role of protecting the health and safety of America's workers and displacing and preempting state law in that field. And so I think the idea that simply because states have that residual police power provides a basis to assume that the OSHA Act can't have any application or that there has to be a specific authorization here of each and every type of mitigation measure is just fundamentally inconsistent with Congress's policy as embodied in that act.
What do we make of the fact that Congress, OSHA has not traditionally mandated other vaccines for other hazards that could pose a grave risk, some might say? The flu kills people every year. Other grave diseases do too. And there are vaccines against many, and we don't need to list them all. But traditionally, OSHA has not regulated in this area.
I think that that's explained by the fact that COVID-19 is an unprecedented pandemic that has a magnitude and proportion that OSHA has never seen before.
I mean, people forget polio, but that was a pretty bad, you can call it a pandemic, you can call it an endemic, I don't know what you'd call it, but it was a terrible scourge on this country for many years. We have vaccines against that, but the federal government through OSHA, so far as I know, and you can correct me, does not mandate every worker in the country to receive such a vaccine. We have flu vaccines. The flu kills, I believe, hundreds of thousands of people every year. OSHA's never purported to regulate on that basis. Well, what do we make of that when we're thinking about what qualifies as a major question and what doesn't?
Well, with respect to other diseases where there are effective vaccinations, I think the simple explanation for why OSHA hasn't had to regulate workplace exposure to that is because virtually all workers are already vaccinated. With respect to many of those diseases, all of us have at one time or another been subject to compulsory vaccination
Is that true
requirements.
with the flu?
Mostly.
Do we know that to be true with the flu?
So flu is an exception because it's a seasonal illness. And there, I think that the explanation for the failure to regulate is that it doesn't present anything approximating the kind of hazard or danger to workers as COVID-19. I don't want to suggest that
Are
it
you
would be...
suggesting that it doesn't pose a grave risk?
I think that the agency would have to build the record to demonstrate that it would clear that statutory hurdle.
But it might.
It would depend on the evidence. Certainly, if there were another 1918 influenza outbreak like the country experienced before, yes, absolutely, I think OSHA could regulate exposure to influenza in the workplace. That's similar to what's happening with COVID-19 right now.